On a November night in Everett, Washington, a man called 911 and told the dispatcher his girlfriend had hanged herself. 19 months later, the medical examiner's office still would not call her death a murder. The official manner of death in the final report was one word: undetermined. And then 12 jurors looked at that same evidence and convicted him of murder in the first degree. This is the story of how a case that forensics could not close was closed anyway. You're watching Nightfall Files. Everything in this episode comes from court records and published reporting. Nothing has been invented. November 16th, 2024, a Saturday. An apartment in Everett, Washington, about 30 miles north of Seattle. Lindsay Geary was 37 years old. That evening, the call came into Everett police. A report of a suicide. A woman, unresponsive. The man on the phone was her boyfriend. His name was Nestor Hernandez Melgar. He told the dispatcher she had hanged herself. Officers arrived at the apartment, and this is the first detail that would matter at trial, more than a year and a half later. According to prosecutors, it took Hernandez Melgar more than a minute and a half to open the door. 90 seconds. For a call he had made himself about a woman he said was dying on the other side of that door. Inside, officers found Lindsay Geary on the bathroom floor. There was a rope near her body, but it was not the rope that got him arrested that night. It was a piece of paper. There was an active domestic violence, no contact order in place. He was not legally allowed to be there at all. So officers arrested him at the scene on the order violation before anyone had determined how Lindsay Geary died. A no-contact order is not advice. It is a court instruction with a criminal penalty attached. Being in the same room is, by itself, the crime. Officers do not need to know what happened inside to make that arrest. They only need to know he was there. So the machinery started for a reason that had nothing to do with how she died. He was booked. His clothing, his phone, his statements, the scene itself, all of it was now inside an active criminal process instead of being cleared away as an unattended death. That arrest is the reason this case exists. Without it, he walks out of that apartment as a grieving boyfriend, and the file is stamped suicide, and nobody ever asks another question. And there is a version of this night that happens in a lot of American cities. A man calls it in. The scene matches the story. The manner of death comes back undetermined. The file closes quietly, and no one is ever charged. Because nobody was ever held long enough for anyone to look twice. But he didn't walk out. And once investigators started pulling on the thread, the story he told began to come apart. Before this becomes a case file, it needs to be a person. Lindsay Geary was 37. She had a family who saw her, spoke to her, and made plans with her. And that ordinary fact became one of the most important pieces of evidence in the entire trial. Prosecutors called members of Lindsay's family to the stand. They testified about the last time they saw her, earlier that same day. They said she was happy, not fine, not holding it together, happy. She was making plans. Plans for the upcoming holidays. Plans for birthday celebrations that were still weeks away. Think about what that means in a courtroom. A person who is quietly planning to die that night does not usually spend the afternoon organizing a birthday party for someone else. It is not proof, but it is a very loud kind of evidence. The defense would argue that you cannot know what is inside another person's mind, that people hide it, that people smile in the afternoon and are gone by midnight. And that is true. It happens. So the jury was left holding two versions of the same woman. The one her family described that afternoon, and the one the man in that apartment described that night. Only one of them could be right. Here is where this case becomes genuinely unusual. Because in most murder trials, the medical examiner is the prosecution's strongest witness. In this one, the medical examiner never said the word. And to understand why that mattered so much, you have to understand what a forensic pathologist is actually allowed to do. They are not investigators. They do not weigh a suspect's history or a protective order or a delayed 911 call. They examine a body and report what the body can support. The cause of death was determined: asphyxia due to ligature compression. In plain language, she stopped breathing because something was compressed around her neck. But cause of death and manner of death are two different findings. Cause is the mechanism, what physically stopped the body. Manner is the category: natural, accident, suicide, homicide, or undetermined. A final report from the medical examiner's office, more than 6 months after her death, listed Lindsay Geary's manner of death as undetermined. Not homicide, not suicide, unknown. And it stayed that way. Through the investigation, through the charging decision, through jury selection, through a 4-week trial. To this day, on paper, nobody has officially ruled that Lindsay Geary was killed by another person, except a jury. Then there was the DNA. When Lindsay's body was processed, investigators looked for the thing you would expect to find if a person had been strangled by someone else. His DNA was not on her neck. It was not under her fingernails. There was nothing on her body that put his hands on her. And the absence of DNA was not a technicality. Juries have been told for 30 years that a struggle leaves something behind: skin under nails, contact on the neck. When a prosecutor cannot produce that, the defense does not have to prove anything. They only have to point at the empty space. For the defense, this was the entire case. No manner of death, no DNA, no witness. Her own phone, as we will see, carrying searches about suicide. Public defenders argued that all of that added up to one thing, and it is the thing the entire American justice system is built around: reasonable doubt. And on paper, they were not wrong to argue it. Cases have collapsed on far less. So how do you convict a man of murder when the science will not say it was murder? The answer prosecutors gave the jury did not come from that one night. It came from the months before it. Prosecutors described the relationship between Lindsay Geary and Nestor Hernandez Melgar as volatile. That word was not decoration. It had a paper trail behind it. Police had been called to the home for domestic disputes on multiple occasions. Not once, not a single bad night. A pattern documented in official records by people whose job is to write down what they saw. To get one of these orders, someone usually has to walk into a courthouse, fill out a petition, describe what has been happening to them, and ask a stranger in a robe for protection. It is not automatic and it is not private. It is a person saying, on the record, that they are afraid. 2 months before Lindsay Geary died, a no-contact order was issued against Hernandez Melgar. That is not a small thing. A court looked at this relationship and decided that the safest available option was to legally separate them. And then there is the date that sits in this timeline like a stone: 8 days. 8 days before Lindsay Geary's death, Everett police were called to the apartment again. The allegation that night was that Hernandez Melgar had tried to break into the apartment. Read that back slowly. A court had already ordered him to stay away. 8 days before she died, police were called because he was allegedly trying to get in. And on the night she died, he was inside. This is what prosecutors built their case out of. Not forensics, history. And it is worth saying plainly what the record does not show. No one testified that they watched him do it. There is no confession in this case, no camera in that bathroom, no neighbor who heard the exact moment. Everything the jury was given, they had to assemble themselves. Because here is the uncomfortable truth that this case forces into the open. Strangulation is one of the most dangerous warning signs in intimate partner violence. And it is also one of the hardest things to prove after the fact. It can leave very little behind, which means the cases where it matters most are often the cases where the evidence is thinnest. Investigators were not looking at a mystery man. They were looking at a man a court had already been warned about, twice. 4 weeks of witnesses, records, and expert testimony over a death that took only minutes. That is what it cost to establish something the physical evidence would not say on its own. The trial ran 4 weeks in Snohomish County Superior Court. 4 weeks is a long trial. It tells you both sides had something real to say. The defense had the physics of the thing, the undetermined ruling, the missing DNA, and the phone. Data pulled from Lindsay Gary's phone showed multiple searches on the night of her death about how a person could kill themselves. If you are the defense, that is the single most powerful fact in the room. Her phone, her searches that night. And this is where the case turned. Because prosecutors did not try to explain those searches away. They asked a different question. Who was holding the phone? Prosecutors argued that Hernandez-Melgar also had access to Lindsay's phone and could have performed those searches himself. Think about what that reframes. The defense's strongest evidence, the searches that proved she wanted to die, becomes, in the prosecution's version, the opposite. Not a woman's last thoughts, a story being written for the police to find. And then it stacks. The delay in calling for help, the 90 seconds at the door, the no contact order he was violating simply by standing in that room, the break-in call 8 days earlier, the family who watched her plan a birthday party that afternoon. No single one of those is proof. Any one of them alone has an innocent explanation. A man panics, a door sticks, a person hides their pain from their family. But juries do not weigh facts one at a time. They weigh the whole pile. And they ask themselves the oldest question in any courtroom. What is the reasonable explanation for all of it at once? On June 22nd, 2026, after 4 weeks of testimony, the jury returned. Nestor Hernandez-Melgar was found guilty of murder in the first degree, along with several additional felony counts. Convicted of a killing that the medical examiner's office, on paper, had never called a killing at all. And it is worth sitting with what that verdict actually required. In Washington state, murder in the first degree is not simply killing someone. It requires premeditated intent. Premeditation, meaning the jury did not just decide that he did it. They decided he thought about it first. That somewhere in that apartment, before it happened, there was a decision. And then there is the part that came after. The rope left where it would be found. The bathroom, the phone, the call. The version of the night that was ready before the police ever arrived. Prosecutors were not only alleging a murder, they were alleging an author. A conviction is not the end of a case in the way television suggests. There will be sentencing. There may be appeals. The defense arguments that failed in front of this jury, the undetermined ruling, the missing DNA, the searches on her phone, do not disappear. They become the grounds someone will raise again later. Hernandez-Melgar was scheduled to be sentenced on July 22nd, 2026. In Washington state, a first-degree murder conviction carries a sentence measured in decades. For Lindsay Gary's family, that date does not close anything. They spent 19 months waiting for an institution to say out loud what they believed from the first night. And even now, the official medical record does not say it. That gap between what a family knows and what a document will certify is the quiet cruelty running underneath this entire case. Because the medical examiner was not being careless. That office was being honest. Undetermined does not mean nobody cared. It means the physical evidence, standing alone, genuinely could not distinguish between two possibilities. A forensic pathologist is not allowed to guess, and that is the thing most people misunderstand about forensic science. We have been trained by television to believe the body always tells you. One fiber, one cell, one certainty. The reality is that ligature deaths can be forensically ambiguous by their nature. The mechanism that kills is the same. The marks can be similar, which means the science can tell you how someone stopped breathing and still not be able to tell you who decided it. So the question moves out of the laboratory into the room where 12 ordinary people sit and decide what a pattern means. And the pattern here was documented long before that night. Repeated police calls, a protective order granted by a judge, an alleged attempt to break in, 8 days out. A woman who, by the time she died, had a legal document declaring that being near this man was a risk to her. Advocates who work in domestic violence have said the same thing for years. And this case is a hard illustration of it. Non-fatal strangulation in a relationship is treated as one of the strongest warning signs that a partner may later be killed. And it is also one of the most difficult things to evidence because it can leave so little behind, which produces a terrible symmetry. The clearest warning sign is also the hardest thing to prove. There is one more thing this case leaves behind, and it has nothing to do with either of the people in it. For years, the standard assumption in cases like this was simple. No manner of death, no case. A prosecutor looks at a file marked undetermined and understandably sees a trial they will probably lose. This verdict complicates that assumption, not overturns it. One county jury does not rewrite the law, but it demonstrates that a case built on documented history, timeline, and behavior can carry a first-degree conviction even when the forensic file is silent. Whether that is justice or a warning depends entirely on whether they got it right. And that is not a question this channel gets to answer. What we can say is what the record shows. A woman was alive on a Saturday afternoon, making plans for a birthday. By that night, she was dead on a bathroom floor. The only other person in that apartment was a man a court had already ordered to stay away from her. He said she did it to herself. The science would not take a side. The jury did. If you take one thing from this episode, let it be this. The no contact order in this case was not ignored by the system. It was granted. Police responded. Reports were filed. Every step worked the way it is supposed to work. And it was not enough. That is not a failure of paperwork. It is the limit of it. It is easy, in a story like this one, for the victim to become a set of forensic findings, a cause of death, a negative DNA result, a phone log. But every one of those documents exists only because a person is gone. Lindsay Geary was 37 years old. She had a family who saw her that day and remembered her as happy. She was planning a birthday she never got to attend. Her name is the reason this case is worth 20 minutes of anyone's attention. Not the rope, not the verdict, her. If you are in a relationship where someone has ever put their hands near your throat, please understand that this is not a normal argument. It is the single strongest predictor that exists. In the United States, the National Domestic Violence Hotline is 1-800-799-7233. I'm going to leave you with a question the jury had to answer, because I genuinely like to know what you think. The medical examiner said undetermined. The DNA said nothing. Her phone said suicide. Her family said she was planning a party. 12 people heard 4 weeks of that and decided beyond a reasonable doubt. Would you have? Tell me in the comments. And if you want the rest of these files, the ones that never made national news, subscribe. This has been Nightfall Files. Thank you for staying to the end.